So now we'll talk about Article 31B. I already told you about Article 31A, and Article 31B, like Article 31A, it was also added by the first Constitutional Amendment Act of 1951. So why was Article 31A added, and why was then Article 31B added? Article 31A, as I told you, Article 31A, it protected the 5 categories of laws, which I have already told you, for being challenged on the grounds that they are in contravention with fundamental rights granted under Article 14 and 19, right? But Article 31B, it had a wider scope. Article 31B, it was added by the first Constitutional Amendment Act of 1951, right, like the Article 31A. But the scope of Article 31B is wide. Why is it wide? Because it protects all the acts and all the regulations, right, which are saved by its Article 31B. It protected all the acts and all the regulations for being challenged on the grounds that they are in contravention of any of the fundamental rights, not just under the fundamental rights granted under Article 14 and 19. That means the scope of Article 31B, this article, is wider as compared to Article 31A. This is the first point. So Article 31B, it was added to the Constitution of India in order to save all the acts and all the regulations by the Parliament as well as by the state legislatures. Yeah, you must remember. So it was added to save all the acts and all the regulations by the Parliament and by the state legislatures for being challenged on the grounds that they are in contravention with any of the fundamental rights, and not just the fundamental rights granted under Article 14 and Article 19, right? So it saved all the laws from the judicial review. So by the first Constitutional Amendment Act of 1951, 13 laws and 13 regulations of the Parliament and the state legislature, they were put under a schedule which is known as the 9th schedule. So this 9th schedule, along with Article 31B, it was added to the Constitution of India by the first Constitutional Amendment Act of 1951, because there were only 8 schedules in the Constitution of India. When the Constitution of India came into being, the 9th schedule, it was added by the first amendment. I told you that the 9th schedule, which was added by the first Amendment Act, this 9th schedule, so this is the 9th schedule, 13 laws were put into the 9th schedule. When the 13 laws, they were put under the 9th schedule, it automatically saved the 13 laws from being challenged in the judiciary for being in contravention with any of the fundamental rights, right? But since after the Keshavananda Bharati case in 1973, the doctrine of judicial review was born. You all know that. In the case of Keshavananda Bharati, the Supreme Court of India, it gave the doctrine of the basic structure, right? And then in the IR Kolo versus the state of Tamil Nadu case, this is a very important case. You must remember the IR Kolo versus the state of Tamil Nadu case. In the year 2007, the Supreme Court of India, through its 9-judge bench, right, which is a constitutional bench, Supreme Court of India said that all the laws which were put in the 9th schedule, right, which were put in the 9th schedule after the date, that is 24th April 1973, they are open to judicial review. Listen what I told you. I told you that there was a schedule which is known as the 9th schedule, which was added by the first Constitutional Amendment Act of 1951 under the Article 31B. This 9th schedule was kept there to put all the laws, to put all the regulations and acts of the Parliament and the state legislature, and not just those acts of the state legislature which received the assent of the President, as I told you under Article 31A. That's why I am saying that the Article 31B, it has a wider scope as compared to Article 31A. Right? So I told you that all the acts and all the regulations which were found to be in contravention with any of the fundamental right, which dealt with the land reforms, which dealt with the abolition of the Zamindari system, which dealt with other matters, they were kept under 9th schedule. Okay? When they were kept in the 9th schedule, a blanket ban was kept there for being challenged on the grounds of contravention with fundamental rights. So they were kept in the 9th schedule, and there was a blanket ban, I can say, on the judicial review of these acts. So they were permanently saved. But in the year 2007, Through the IR Kolo versus the state of Tamil Nadu case, the Supreme Court of India, through its nine-judge bench, constitutional bench, said that all the acts that were put in the ninth schedule after this cutoff date, that is 24th April 1973. Why 24th April 1973? Because it is the date of judgment of Keshavananda Bharati case. The verdict of Keshavananda Bharati case was given on 24th April 1973 and it provided for judicial review. So Supreme Court in IR Kolo case said that all the acts that were placed in the ninth schedule after this date, they are open to judicial review. So what is the current status? Current status is that the ninth schedule of the Constitution of India, it is open to judicial review, but only those acts and only those regulations that were put in the ninth schedule after 24th April 1973. So I told you that initially there were only 13 acts that were put in the 13th schedule. 13 acts were put in the ninth schedule by the first Constitutional Amendment Act of 1951, but the present score is 284. The 284, it is the numbering, but the actual number is 282. There are 282 acts present in the ninth schedule. So all those acts that were put in the ninth schedule before 24th April 1973, they are not open to judicial review, but those acts that were put in the ninth schedule after 24th April 1973, they are open to the judicial review, right? So this is an overall broad view of Article 31B. So you will ask, what is the difference between Article 31A and Article 31B then? Article 31A and Article 31B. Article 31A, as I already told you, that it saves only 5 categories of laws, right? But Article 31B, it saves all the acts and all the regulations, not just 5 categories. Right? So this is the first difference. The second difference is that Article 31A, it saves the laws only for being invalidated for contravention to Articles 14 and 19. But it protects the laws from being challenged on the grounds of being invalidated for being in contravention with all fundamental rights. So the scope of Article 31B is automatically wider. Article 31A, it saved the parliamentary laws, and it saved only the state laws which received the assent of the president. I have already told you. But Article 31B, it saves all the parliamentary laws and all the state laws, irrespective of the fact that whether the state laws, they got the assent of the president or not, from being challenged, right? And Article 31A, it is not open to judicial review. But Article 31B, it is open to judicial review, but only those acts that were put here after 24th April 1973, right? So this is all about Article 31B. I think it is more than sufficient, but you have to remember one more thing which I forgot. In Article 31A, I told you that it saved only those laws which were related to agricultural land reforms, which were related to industry, and which were related to commerce. But Article 31B, it saves all the state laws which deal with the land reforms. You have to remember the state laws which deal with the land reforms and abolition of the zamindari system. You have to remember that. Okay? So it saved all the state laws which dealt with the abolition of the zamindari system and which dealt with the land reforms, and it saved all the parliamentary laws which deal with the other matters. So all these laws, they are saved by Article 31B, and not just the laws of related to the agricultural land reforms, industries and commerce. So this is all about Article 31B. I hope you got an insight in Article 31A and Article 31B. Now we will deal in the next lecture with the Article 31C. Thank you so much for watching.